Hi, I'm Mackenzie Sorge, founder of View Ridge Family Law and Estate Planning. And today I'm going to be talking about discovery. Discovery is probably everyone's least favorite part of divorce and custody and any litigation. It's intrusive, it's time consuming, it can be very expensive. I'm going to be giving you some tips today to help you get a head start and hopefully make your life in this process a little bit better. So what is discovery? Discovery is the process of finding out information, collecting data, gathering facts, and exchanging that with the other side. It happens after a petition has been filed and after a response to that initial petition has been filed by the responding party. The common forms of discovery are interrogatories, requests for productions, subpoenas, and depositions. Many of those involve a 30-day turnaround. And 30 days might sound like plenty of time, but trust me, it goes by very quickly. So when you get a discovery request, you want to get started right away. Let's talk about interrogatories and requests for production. These are the most commonly used forms of discovery in divorce and custody and probate litigation. When you get one of these requests, you want to, number one, schedule plenty of time to deal with it. Set aside a weekend and evening so that you can pay attention to what you need to gather and give thorough answers. Number two, organize it. Get it organized for your attorney so that you can save yourself some money and not have to pay your attorney's office to put it all together in an organized fashion. It does have to go off to the other side in an organized way. And if you don't do that, you can be fined. So the more that you can put it together, the quicker it's going to be. Finally, give your materials and your answers to your attorney with plenty of time before the deadline. They need time to make sure you've adequately answered and that you've not given too much information that goes beyond what's been asked. And they need, again, to make sure it's organized so that you do not get into trouble. My next big tip is to be mentally prepared for the invasiveness of discovery. Contested litigation is an expensive, invasive process, and each attorney has a duty to do due diligence to look into every nook and cranny for information that might be relevant. It's the reality of contested litigation, especially in parenting and divorce cases. All of your life together or all of your history as a parent is going to be examined and exposed in this process. So you just need to be prepared for that. There is no way of getting around discovery. If it is posed to you, you just have to get through it. And the sooner you accept that, the easier your life is going to be. You get to ask discovery from the other side as well. So work with your attorney to hone in on what is important to you and the matter and how to move it forward. Also listen to your attorney about what is going to be important from the court's perspective when we go to discover information. Many times people have pet peeves about their ex, but there may or may not be material to dividing up your property or parenting issues, so they may not really be worth pursuing. Work with your attorney to find the information that's relevant to your matter. If you are dealing with the discovery process, know that it will not go on forever. Give yourself some space and time to work through it, get it done right, and it will make your life a lot easier. I also recommend working with an experienced attorney who knows how to handle discovery. Also going to make your life so much better through this difficult process. If you need help, just give us a call.